We continue to look at limitations imposed on testamentary freedom in terms of what can the testator do and what are the limitations imposed. We recently looked at the fact that a testator cannot disinherit a spouse. The spouse has a right to elect against the estate to the extent the spouse is disinherited. We're now going to look at some other limitations, including the pretermitted heir and the slayer. All right, so just as a review for the elective share, there are two main approaches, the traditional and the augmented. The traditional is something that Maryland followed until 2020, very easy to calculate, however, does not provide adequate protection, and common law supplements which require litigation are necessary. Maryland followed the fraud on marital rights theory in the Nell v. Price. Other jurisdictions use something called illusory trust so that it's bringing those non-probate assets back in for purposes of calculating the elective share. Many years ago, and starting in 1969, the UPC recognized that the traditional method was no longer adequate because it failed to take into consideration non-probate assets. Therefore, it expanded its calculation of the elective share, has made several adjustments to the initial statute, but currently includes both probate and non-probate of both the decedent and the spouse, takes into consideration the length of marriage by calculating the marital portion of that pot, uniquely takes into consideration the spouse's own property, and keeping in mind, once you move things outside the probate arena, collection becomes difficult. After many years of attempting to change the law in Maryland, finally in 2020, Maryland enacted something called the Maryland Estate Subject to Election. It is not an augmented estate, although that term is used. It's very different. It has many adjustments, offsets for trusts, and also uniquely allows the modification by a court which came from the Shakroon case. Collection has been difficult, and in fact, it has increased the litigation in the elective share arena. All right, so what are some of the other protections that we need to be aware of? One of the things that you might see is that the testator tries to limit a beneficiary's inheritance by conditioning it on not marrying, encouraging divorce if they don't like a stepdaughter or stepson, and those will not be tolerated. You cannot encourage divorce, and you cannot condition a bequest on not marrying. There is one exception in second marriage situations, so a testator may provide additional support to his or her spouse until remarriage. That is fine and does not violate public policy. Don't forget the spouse is otherwise protected with the elective share. This would be something in addition to that. We also need to be concerned about a forgotten child, and that's referred to as the pretermitted child, and we needed a way to prevent persons responsible for the killing, the slayer, to inherit from the victim under an unjust enrichment theory historically, which has ripened into the Slayer Act. The one case we look at on the public policy piece is the Shapira case, and it points out a couple of very interesting things. First and foremost, the testator did not have to provide for his son Daniel at all, could have completely disinherited a son and children. So whether or not the limitation imposed on the son's inheritance was enough to violate public policy, keeping in mind Dr. Shapiro didn't have to leave anything to Daniel at all. We look at the restriction. They ultimately see if it was a reasonable restriction, And keeping in mind that Dr. Shapiro could have placed this condition on Daniel by gift, and something even stronger on by gift. The pretermitted heir. Anytime you see a child born after the execution of the will and not provided for in the will, you need to think about whether or not that child could bring what's called a pretermitted heir claim. It is very important in most jurisdictions that the child be born after the execution of the will and there be other children who are taking. The calculation provides that pretermitted heir with the lesser of intestacy or average child, which means you take what the other child, the named child, is getting and divide it by the number of total children to determine whether or not there is a pretermitted heir claim. The problem does exactly just that, keeping in mind that you would take the entire estate, divide it by the number of total children to get what the average child would be. That amount would be exactly the same under intestacy or the will. If the testator was married at the time, you would have to also take into consideration either the spousal's elective share, if there's a will, or intestate share if the person died without a will, in which case the amount that the child would be entitled to would be much less. The slayer is a limitation on who can be a beneficiary. Historically, this was a part of common law in Maryland. There were major changes in that it applied to the non-probates. And the important piece is that the descendants of the slayer are not precluded from taking just because of the slayer's bad act. So we treat the slayer as predeceasing, and we allow that money to pass through the slayer to the descendants if we're talking in terms of intestate succession. Felonious and intentional, so not accidental. We treat the slayer as disclaiming. Remember from when we looked at disclaimer, we cannot apply lapse to that because we can't pretend someone is predeceased for Maryland's lapse statute. Also under the statute, we can prevent the slayer from serving in any fiduciary capacity. We sever the non-probate, and we eliminate any right to take as a beneficiary under a beneficiary designation like life insurance or retirement, and others. So we take a look at a situation in which son kills father who died intestate. Father died intestate. Son would have taken. Son cannot take as a result of being a slayer, so it would pass through son to any more remote descendants, and if not, then it would go up to the parents of the father and down. This was tested on the 2015 bar exam and very similar to the problem, and it's important that you note that the slayer is only prevented from inheriting from the victim. So it doesn't matter if the victim left all property to someone who then leaves it back to the slayer. That is not a problem. Okay,